Hey everyone, this is Jeff Epstein with Truth Against the Machine. I want to tell you about the case of the frozen trucker. And this is a prime example of how Neil Gorsuch, the judge that Donald Trump has nominated to the Supreme Court to fill the final ninth open seat, how he rules, how he thinks. So there, in 2009, in January, 11 o'clock at night, a trucker named Alphonse Madden is driving in Illinois, and he pulls over to the side of the road, 11 o'clock at night. He calls his company, Trans Am Trucking, and he tells them that the brakes on his trailer have frozen. They're stuck in the applied position, and that the heater in his cab, the part that he drives, is broken, and that he's running out of gas. So they tell him, we will send a repair crew to you in about an hour. Just hold on. So 2 hours later, Madden is woken up by a phone call by his cousin. And when he wakes up, he realizes that his legs are numb, his torso is starting to become numb, his feet are turning blue, he's having trouble breathing, and his voice, his speech is starting to slur. So he calls his company again and says, I'm in trouble. The repair crew is still not here. What do I do? And they said, wait, the repair crew is on their way. He waits another half hour, and now he's concerned that if he continues to wait, that he could die of hypothermia. So he makes the decision to unhitch the trailer from the cab and to drive and get gas, because dragging this trailer with its broken brakes stuck on is going to make the gas, it won't last. So he gets out of the truck, he walks back 50 feet, the length of the trailer is 50 feet, he walks, he locks the doors, he unhitches the trailer, and I want to read to you how he describes that experience. When I stepped out of the truck, I was concerned that I may fall, because I was on the verge of passing out. I fear that if I fell, I would not have the strength to stand up and would die. I walked to the back of the trailer to place a lock on the cargo doors. The distance that I walked to the back of the trailer seemed like an eternity, as my feet absolutely had no feeling at all. So he called his company. He said, I've made this decision. I can't wait any longer. I'm really scared for my health. The company said, do not do that. Madden went ahead and did it. He unhitched the trailer. He drove to get gas. He warmed up. He came back. He was back in about 30 minutes. When he came back, he found that the repair crew was working on the brakes. They fixed the brakes. They fixed the heater. And then Madden continued on his way and finished his job. So 1 week later, Madden is fired because he abandoned his cargo and he disobeyed orders. So Madden filed a complaint with OSHA, OSHA, the Occupational Safety and Health Administration. They denied his claim, but then the Department of Labor ruled in his favor, and then the company appealed that decision to the 10th Circuit Court of Appeals. So in 2016, 7 years later, the 10th Circuit Court ruled that Madden was in his rights and the company had no right to fire him. And what the company tried to justify their firing was this statute. And the statute says that it is unlawful for an employer to discharge an employee who refuses to operate a vehicle because the employee has a reasonable apprehension of serious injury to the employee or to the public because of the vehicle's hazardous safety or security condition. So what the company tried to get away with, what they said made it okay for them to fire him, was that this statute says if he refuses to drive in an unsafe manner. And the company claims that he didn't refuse to drive in an unsafe manner. He chose to drive. And choosing to drive it is not the language of the statute. The language says refuse. He chose to drive. He did not refuse to drive the truck in an unsafe manner. I mean, this is word salad, but this is what the company said. He didn't refuse to drive in an unsafe manner. He chose to drive. And therefore, they had the right to fire him. And the court said that's not valid. And 2 of the 3 justices said his choosing to drive the cab in a safe manner was his expression of refusing to drive the entire truck in an unsafe manner. So the court ruled that the company, number 1, had to pay him retroactively from 2009 to 2016 with interest. And number 2, that they had to expunge all negative records related to this incident, both internal and that they have communicated to others. The company actually fought this back pay ruling by saying that the justice system moved too slow and they shouldn't have to pay for that delay, which is, completely ignoring the suffering that Madden had to go through during those 7 years with no pay, with the stress of this case, and also the negative reports that the company gave that affected him when he applied for other jobs. So 2 of the 3 judges went in Madden's favor and he won. 1 of the judges didn't, and that judge was Neil Gorsuch. And what Gorsuch said was that the company was correct, that the statute didn't say that operating the vehicle is covered by this statute. The only thing covered by this statute is refusing to operate in an unsafe manner. So Gorsuch acknowledged that the option of driving the cab with the frozen brakes was an illegal and maybe sarcastically offered option. So he acknowledged that that option really wasn't an option. And the other option of waiting as commanded, that option was legal if unpleasant. Legal if unpleasant. And he also said that Trans Am permitted him to sit and remain and wait for help, as if waiting to die was one of a number of options that the company provided to him. So here is the crux of Gorsuch's argument. In his dissent, he says, "My colleagues suggest that the Department of Labor should be permitted to read the statutory phrase, 'refuse to operate,' to encompass its exact opposite and to protect employees who operate their vehicles in defiance of their employees' orders. So the statute only protects employees who refuse to operate in a dangerous manner. It does not protect employees who operate things in defiance of the employer." He says that it might be fair to ask whether Trans Am's decision was a wise or kind one, but it's not our job to answer questions like that. Our only task is to decide whether the decision was an illegal one, which is his way of dismissing all of the suffering and the human condition that is related to his dismissal. And the majority justices say that his refusal to operate the truck is inextricably intertwined with the decision to fire him. But Gorsuch just sets that aside and dismisses it as irrelevant and inconsequential. So the letter of the law put Madden in an impossible and absurd situation. He only had 2 options, 2 legal options that were provided him by commands by the company, his company. Number 1 was, from his point of view, to sit and wait and potentially die from hypothermia. He had no idea how long it was going to take. It was already 3 hours by this point. The other option, which Gorsuch himself says is sarcastic and nonsense, is that he could have driven the truck, the entire truck, with its stuck brakes in frozen weather with his mind completely being affected by the oncoming hypothermia, driving at 10 to 15 miles an hour, dragging it, while other cars are traveling around him at like 75 miles an hour. So either he could choose to endanger his own life or endanger the life of the public. And he chose to do neither. So the majority criticized Gorsuch's dissent as Gorsuch just chose a dictionary definition, whatever one fit his narrative. And he chose this definition of refuse that it doesn't fit provide to operate. And the majority said that his choosing to operate it in a safe manner was his expression of refusing to operate it dangerously. So this is just one example of a number of cases where Gorsuch takes the letter of the law, ignores the human suffering, the human condition that the law may cause, and therefore render the law unconstitutional. And he especially does this when it's to the benefit of corporations, of the powerful, of big business. And there are a number of examples that show that this kind of ruling, this literalism, is indicative of how he rules in favor of the powerful, in favor of the police, in favor of big corporations, at the expense of individual rights and civil rights and minorities. And Madden is an African American. So the Supreme Court for the past 40 years has been ruling in favor of corporations. And if Gorsuch is put on that Supreme Court, it's just going to be another blow for individual rights.